Dre, when your client claims this yearsly protection, is your client saying, I satisfied the yearsly criteria and that shows that I did nothing wrong? Or is your client saying, I satisfied the yearsly criteria, that means that even though I did something wrong, it was in fact, I am in fact protected from legal consequence?
The latter. So in fact, immunities are only useful when they protect. Same thing with defenses.
Well, go ahead. Explain to me why it's the latter, because it seems to me that the yearsly criteria suggests that you're saying the former. In other words, when somebody says, look, I did only what the government authorized by way of a lawful authorization, what I'm really saying is, so how could I have done anything wrong?
Oh, okay. So consider the Cunningham case from the Fourth Circuit that we cite, which Judge Floyd gives a great exposition of this doctrine. In that case, it's kind of like Campbell-Ewald, except the instruction was essentially violate the TCPA to reach out to people who had not consented to be contacted. That instruction would definitely violate federal law, but the Fourth Circuit quite appropriately applied yearsly to conclude that the contractor was immune from suit because it was following the government's instructions. So that's why I say it falls into the latter category.
Well, I'm following the government's instructions, and the government's instructions are lawful, so obviously everything I did was lawful too. Isn't that the sort of rationale of yearsly?
No, Your Honor, and this is an important point. My friends on the other side rewrite yearsly's first condition to say, was it lawful? That has never been announced as the first yearsly condition. And it doesn't make any sense to say that you enjoy an immunity or even a defense or even a derivative privilege or whatever the SG's office has for us. That doesn't make any sense if what you've done complied with the law. The value of an immunity, and again, the Cunningham decision, to which I commend to the court's attention, does a great job of analyzing this. It only does any work if the person could have been liable. So the government's instruction may have been violate the TCPA, consider Campbell-Ewald, but change one of the facts. Suppose they had said, the Navy had said to the contractor, carpet bomb every 18 to 24-year-old in America with a text asking if they'd like to join the Navy. In that case, the contractor in Campbell-Ewald wouldn't have had to make the argument that it was entitled to the government's absolute immunity. It would be able to argue that it was following the government's instructions and comes within yearsly.
Wouldn't get the